Hi, everyone. Thank you for joining us today. I'm Blair Botsford, partner in the tax group of Dentons Toronto office, and I'll be your moderator for this session. Today, we're going to be discussing compliance issue spotting and key considerations to keep in mind in relation to the movement of people, activities, funds, and information across borders for charities and not-for-profits in Canada and the US. We have a fantastic panel assembled today. And I'm going to introduce them to you. We have Christie Tillapaugh, a shareholder based in Pittsburgh and serves as chair of the Dentons, Cohen and Grigsby nonprofit and tax exempt organizations group. She has over 20 years of experience serving as outside general counsel. She also provides corporate governance and strategic transaction related counseling for a wide range of nonprofit clients. Kelli Wikoff is a member of Dentons tax practice based in Kansas City and counsels a variety of nonprofit organizations on obtaining and maintaining federal and state tax exemption, as well as related nonprofit compliance matters. Tony Manconi is a consultant in the tax group of Dentons Toronto office. He joined us following a 34-year career in the federal government, working with a number of departments, and has extensive knowledge on the machinery of government, the government role of tax regulators. And just prior to joining us, he was the director of Charities Directorate of the Canada Revenue Agency, where he was responsible for the regulation of registered charities under the Income Tax Act. And finally, and certainly not least, Pamela Shin is a partner in the tax group of Dentons Toronto office, and she specializes in charity and not-for-profit law. She partners with impact-focused organizations to enable their missions and co-create transformative social outcome. Pam's experience is both as counsel to and senior leader of the world's largest charities. She provides her clients with rich integrated legal, business, and cultural perspective. So that's our panel. And we're going to move into the first topic of discussion, which is the meaning of compliance excellence. So Pam, if you can get us started and tell us what is meant by compliance excellence.
Great. Thanks, Blair. And thanks, everyone, for taking time out of your busy schedules to join us today. It's such a pleasure to be meeting with you like this, even though it's only a digital interaction. We're grateful that you could join us. So compliance excellence at its core, it's a mindset that prioritizes good governance and ethics. To actualize this mindset, it's important that compliance excellence be demonstrated at the highest levels of an organization. So really, it's about setting the tone from the top. In substance, compliance excellence requires an understanding of compliance requirements across both topics and geographies. So knowing the answers to key questions like, where do we have programs, where do we have operations, and what legal and regulatory requirements must we comply with in order to maintain good standing in those places. Gaining a clearer understanding and awareness of the requirements is one part of the challenge, and then adhering to those requirements is also critical to compliance excellence. Therefore, it's important to measure good governance and ethics through tangible target outcomes, things like internal cultural indicators, enterprise risk management programs, and even things like external recognition and accreditation. Finally, a critical pillar to compliance excellence is to enable a healthy feedback loop. This is to ensure continuous improvement and learning. And we're starting with this question, what is compliance excellence today? Really to establish a common understanding of our why. Why are we here to discuss key compliance considerations for charities and not-for-profits in Canada and the US? At minimum, it's because we care about the good governance and ethics of our organizations and their impact in communities and the world. It's because we care about how, not just what, our organizations do.
Great. Thanks for setting the stage, Pam. Now, Tony, over to you. Can you talk to us about who should be accountable for compliance of charities and not-for-profits? And of course, Pam, feel free to jump in and weigh in as well.
Sure, happy to do so, Pam. Sorry out there. Accountable is such a scary word for some folks, but it actually shouldn't be. I would say anyone who carries out any part of a charity's operations is actually accountable for compliance. So what I mean by that is whether you're either filing a donation receipt or you're filing an annual information return, you should do so in adherence with the compliance rules. So basically, being accountable means following the rules, policies, procedures, whenever you're doing any type of work. With this mindset, it ensures that whatever you're doing doesn't put your charity at risk of losing its charitable status. And as for board members, they should continuously be looking to lead by example and demonstrating compliance in the decisions and their actions. And in addition, they should ensure that their ongoing enterprise risk management is in line with changing legislation as guidance changes as it happens. And any additional thoughts on that?
Thanks, Tony. Yeah, I couldn't agree more. Compliance excellence is all about ownership across a whole organization and not just by one particular individual or function. But I think it's important to point out the special role of the board. The boards of charities and nonprofits, they act as the directing mind of their organizations. Essentially, they're fiduciaries to the organizations they serve. Meaning they must serve the best interest of the organization and not a self-interest. The fiduciary duty requires boards to manage or supervise the management of the affairs of the corporation. So while compliance accountability should be owned across the whole organization, it's important to keep in mind that ultimate accountability really lies with the board of directors. Your organization might call it a board of trustees or a board of governors. It's the boards of charities and nonprofits that should maintain compliance and ethics really as a standing agenda item in their board and committee meetings to keep it top of mind.
Great. Thanks, Tony and Pam. Very interesting. So Kelli, can you tell us about some unique challenges that charities and not-for-profits face when dealing with compliance?
Yeah, absolutely. I think that one of the main challenges I often see nonprofits encounter is just the fact there's so many types of nonprofits, and like understanding what nonprofit you are and where you kind of sit in the compliance obligation world can be really challenging. I mean, we have higher education nonprofits, family foundations, community foundations, other public charities, you have trade organizations, social clubs. I mean, there's a wide gamut of nonprofits. So again, understanding where you sit and what your unique obligations are is really challenging, but it's also really important. Another challenge I'll often see is just a misperception, at least in the US, about nonprofits. If you haven't worked in the nonprofit sector, I often will see, and you're coming from the for-profit sector, I'll often see people believe that running the nonprofit's like running a for-profit, but with no tax obligations and no tax burden. But that really isn't true. I think, and nonprofits are subject to a lot of regulation, which leads to the compliance obligation. So I think one of the challenges is just underestimating what your compliance obligations are going to be.
Okay, thanks, Kelli. Tony, did you have anything you wanted to add to Kelli's comments?
Yeah, I guess I would start by saying everybody knows that the legislation, the Income Tax Act, is really complex. So, it's hard for a lot of folks to follow. Secondly, charities feel that, the CRA guidance is sometimes written more for lawyers than and in plain English for everyone to follow. There are a lot of volunteers, not everybody's a lawyer, so those guidances can be pretty complex to understand. And lastly, some organizations want to be really aggressive with their mandates. They want to be forward thinking with their programs, but oftentimes legislation and the guidance just doesn't keep up with the pace that the charities would actually like to move on. So I see these as pretty big conflicts for them.
Okay, thanks, Tony. So I'm wondering what charities can do to manage costs associated with compliance, because it's sounding like it can be a costly exercise. Kelli, do you have some thoughts?
Yeah, I think one thing that we often will recommend our clients do is to form a relationship with an expert in the nonprofit world, particularly the compliance world, whether that's a lawyer or an accountant or someone else who has some background in compliance. And that way you have access to somebody that you can at least ask questions of. And often it's an issue spotting sort of exercise, like not actually having to do a lot of research or work, but just, if we do this, what do we need to think about? What are the challenges? The other thing that I think has to happen is, and Pam alluded to this earlier, the board or the executive, they need to set the tone that compliance is important and there needs to be a budget provided for that. And that allows everyone in the organization to anticipate issues and be able to actively take proactive steps to ensure compliance.
Thanks, Kelly. And Tony, any further thoughts?
Yes, so similar to what Kelly mentioned, it's better to ask first. That's my party line. So what I mean by that is, don't be afraid to call the CRA Charities Directorate and ask for clarification of the rules to ensure that they're in line with the activities that they want to do. There's a big fear factor with the CRA, but that's not really the case. They're there. There's a bunch of folks ready and willing to help out with questions that they may have. Another point I'd like to address is the fear of being audited all the time. I know charities that spend a lot of money and a lot of resources every month making sure that their charity's up and running properly and that that everything's on the fine line. I would say focus on your mission. As long as you have a good compliance protocols in place and you're making the right inquiries, you can reduce concerns about getting audited. And at certain points along your journey of your new programs or as you evolve, take a step back, ensure that compliance is being adhered to, and you should be in pretty good shape.
Okay, great. Thanks, Tony and Kelly. So we're going to move on to the next topic, being good governance. And Christie, if you could start us off, talk about some of the key governance consideration that boards of charities and not-for-profits should keep in mind.
Great, thanks, Blair. And building on what some of the concepts that have been to date, really some of the best compliance comes from having an engaged board. And I know Pamela spoke about this earlier, but having a board that is well trained and understands its responsibilities is critically important. And in a duty of loyalty perspective, it's really important that the board understand that it's engaged in independent decision-making, and conflicts, which you'll hear about in several places, is a really, really important topic for nonprofits. I think well-intentioned, people often want to help, but they often have connections to the organization. So really understanding when or how a conflict could present, even a well-intended conflict, is important. And so having a process in place to disclose those relationships, collecting them on an annual basis and looking at them really can help arm the board both to make really good decisions and be protected from second guessing when they're trying to help. The second part of that training that is sort of implicit in a lot of things we're talking about is sort of the duty of care, which is an emphasis on process. So really having a process in place that allows the board to document its decision-making, to rely on outside experts as needed, helps the board in both being protected when it makes decisions, so it's protected from second guessing. And I know Pamela will talk about some of the mission-related pieces, but as a board member, being top of mind, thinking about what the mission of the organization is and in ways to safeguard that. And so all of the actions of the board, both from a compliance perspective and otherwise, are really central to the board making good decisions that are well-informed. And that can be as basic, and this will lead into some of the trends we're seeing too, but I'll touch on some here too, about having a board member have a job description where they really understand what the expectations of the board member is and what the expectation that it will do. And so I think when Tony talked about accountability and otherwise, it's very important to know what the expectations are so that there's not a misperception that perhaps it's someone else's responsibility. Also, with respect to shared resources, especially in this environment, we see a lot of desires to share resources. Different nonprofits or for-profit entities may be sharing certain resources for cost saving and very good reasons. So I think it's very important for the board to understand that governance is very important when they think of how they share resources, how they document it, and following a good process. Because with the IRS rules here in the US, oftentimes having a particular process undertaken will give them a presumption of reasonableness, but we really need to know up front that those processes need to be followed. So again, so the board can be protected from second guessing. So again, having that strong foundation of corporate governance really can help them make better decisions and document them, and do so in a way that will really preserve their fiduciary duty status later. Pam, do you have other points you'd like to add?
Thanks, Christie. Yeah, I think, I'll just carry on the point that you were making around the mission orientation. And I think what's so interesting about our conversation today is, although we're talking about issues that are specific to the US and then to Canada, and of course the cross-border element, there's so many common components that are shared in the charitable and nonprofit sector. And really that mission orientation is one of the themes and the common threads that weaves the two jurisdictions together. And so here we need to ensure for boards that their orientation and focus on the mission is laser focused. And then on top of that, understanding that boards are always in some sort of adjustment or growth and different life cycles. And really that's to reflect the organizational life cycle, and making adjustments to governance practices and protocols, although governance principles may be consistent through the years of an organization's life cycle. Some of those practices and protocols might need to be adjusted to really address the changing size of a board or organization, maybe some of the changing activities, or maybe there's environmental and other factors that boards face for them to address and respond to.
Great. Thanks, Pam. So Christie and Pam, can you talk to us about some of the governance trends charities and nonprofits should be tracking? Christie, if you want to start us off.
Sure. And I think Pamela made a really good point. I think regular review of your governing documents is really important. And that requires just looking at them to decide what serves you and what does not serve you. You do not want to fall in a situation where you're not meeting as regularly as you said you would meet, or not following term limits or other things. So having them reviewed annually, ideally, or no less than every 3 years is really important, even if you're not going to rewrite them in a significant way, just to have someone see, do we need all these standing committees? Do we actually need to do things this way? Is really important. So you don't catch yourself in a situation where all of a sudden you realize that you needed a minimum of 7 directors and you have 2 people who are about to roll off, and you're perhaps in a situation where you need to populate the board differently. So I think that's a really good exercise. And also, a lot of people are meeting differently than they have in the past. They may be doing more electronically, or collecting or disseminating information to their board in different ways. So I think looking at both the document retention policy, how are you keeping these records, but also do your bylaws maximize your flexibility to use the technology in a way that serves you? So I think those are very easy changes that can help both from a compliance perspective and a practical perspective. Document retention is also important because we're seeing transitions on board. We're seeing people who may have left the organization or being retired. And so having good records in place is critical, but also doing perhaps new training. Oftentimes when you have board members that may serve on other nonprofit boards, there may be an expectation that they're already trained and may not need it. But as Kelli pointed out, every nonprofit's different. So having some regular ongoing training that your board members can engage in is a value add. And while they may be busy folks, having just that 1 hour way to engage and connect as to their fiduciary duties, we find is something that people really appreciate and often are very grateful to the organization that they have that time and space to ask questions and approach that. The next one I'll mention is just gift acceptance policies. Obviously, being able to thrive as a nonprofit often means that you're relying on the funds of others. So do you have a good policy in place for how to accept gifts, or upon what terms, or when, if you're a private foundation, what to do if somebody approaches you with a donation? So there's just a lot of questions that can come up surrounding gift acceptance policies. So it's best not to be caught flat-footed on this. So having a plan in place as to how you would deal with this, or whether you would accept cryptocurrency or anything like that, it's usually good to just spend some space over the course of a year, and it doesn't have to be a lot, thinking about, do we have the right policies in place that serve us? Whether that's gift acceptance or executive comp or political activity, I think whatever environment you find your nonprofit in, it's good to step back and have the benefit of, the best practices policies that may be out there to inform your decisions.
Pam, was there anything you wanted to add to Christie's comments?
Yeah, I think Christie made some really important comments about that constant review and making sure that we're staying on top of changes. One of the key changes that we're seeing as a trend in governance for charities and nonprofits is looking at really ESG focused organizations and partnering and possibly collaborating with such organizations. And this should come naturally and is increasing really as purposes are generally aligned when you really focus on, for instance, the S component of the ESG with respect to the social purposes. And kind of related to that, given the social impact nature of the sector, the inclusion, diversity, kind of equity and accessibility frameworks, these have really been embedded in program design and organizational leadership, and that trend is only growing. And then, kind of a constant theme, maybe this is not a trend, but something that's always top of mind for charities and nonprofits is accessing new revenue streams, and maybe working differently with the private sector and setting up new structures. For instance, we have clients that are nonprofits that might be looking into setting up wholly owned for-profit subsidiaries as different ways to engage in for-profit activities, but obviously doing that with the proper legal advice and ensuring that there's compliance there. And then the other key trend that we're seeing is reimagining kind of new program areas and expanding operations into different jurisdictions. This is, with a view to accessing a greater donor base and maybe new partners and different contexts in which to program.
Great, thanks, Pam. And so if an organization is facing challenges with board performance, what can they do to get on track or back on track?
Yeah, so I think this is a really important question, and it's important to ask in the context of our discussion today, because healthy board functioning and performance is critical to the success of any organizational change, like exploring cross-border expansions and new program areas. So I would suggest, start by even just going back to the basics, revisiting and retraining on good governance. I would suggest conducting a root cause analysis, because when you have board performance challenges surfacing, they could be related to a whole host of things, or even a combination of factors, including things like board unity, or maybe there's some contextual factors or skills mix, or even leadership challenges at play. So that root cause analysis could be done by a subcommittee or a working group to just provide some structure and streamlining. Depending on how serious the performance issues might be, there might need to be an independent review, particularly where there's issues of non-compliance with laws, for instance, or allegations of misconduct, or there might be high risk of consequences, negative consequences to funding or reputational harm. And certainly ensuring accountability by revisiting metrics towards stronger performance would be advisable as well.
Great, thanks, Pam. So on to our next topic. We're going to talk about charities with cross-border operations. And so, Tony, we'll get you to start off and talk to us about ways that charities and nonprofits can operate outside their home jurisdiction.
Sure, and then this is a great time because there's been a recent legislation that came out that give charities a couple of options to do that. The traditional way was for charities using qualified donees or using intermediaries, to do the work across the borders. And of course, those are through what they call direction and control guidelines by the CRA. But with the recent legislation, charities can now issue grants through non-qualified donees using the CRA grant distribution requirements. And I believe Pam's going to spend a little bit of time going through some of those.
Yep, absolutely. So, the rules that we're talking about here from a Canadian perspective, they're rules that apply directly to the movement of charitable resources. So people, activities, funds, and information. On the point of information, it's important to point out that in Canada, even intangible assets such as intellectual property, these are considered to be charitable assets. So trademarks, research papers, educational materials, and other copyrighted materials fall under the own activities and qualifying disbursement rules. Mm-hmm. So under the Income Tax Act, and some of you on our call might already know this, but I think it's important to point out there is a distinction between qualified and non-qualified donees. So qualified donees is a term that's defined under the Income Tax Act, and it includes, for the most part, Canadian registered charities. There could be other entities that are qualified donees, such as the UN and its agencies. Certain universities outside of Canada are also qualified donees, and then several foreign charities that have been designated as qualified donees. But it's important to note that charities in other countries, even though they might have tax exemption in those jurisdictions, generally they're not qualified donees in Canada. So a 501c3, for instance, in the US, without qualified donee status in Canada, would be a non-qualified donee. And in addition, nonprofits in Canada that don't have charitable status are also non-qualified donees. So under the own activities regime, I won't go into this one in as much detail because it's been around for a while. And some of you on the call might be familiar with the regime, but essentially all of the charities' physical and financial resources, including staff and volunteers, they need to be devoted to carrying out the charity's own activities, which is demonstrated through direction and control over those activities if they're not actually being carried out directly by the charity itself through its own staff and volunteers. So where charities are working with intermediaries, then direction and control can be demonstrated through certain measures like detailed project descriptions, ongoing monitoring and evaluation, written agreements, ongoing instruction to the intermediary by the charity, periodic transfers of funding, and then making sure that the activities and funds of the charity are separate from the intermediary. So the direction and control measures, they've been long scrutinized as impediments to many forms of valuable charitable partnerships. And in June of 2022, changes were introduced to the Income Tax Act in Canada, which now permit charities to make what's called qualifying disbursements. So this includes grants to non-qualified donees. Charities that wish to leverage these new rules, they must ensure that they meet certain accountability requirements. So accountability requirements include that the grant has to further a charitable purpose of the funder charity. And then that fund must be exclusively applied to charitable activities in furtherance of the funder's charitable activities or charitable purpose rather. And then the funder charity has to maintain documentation that's sufficient to demonstrate these requirements. So CRA's draft guidance on this topic, it's meant to help charities understand how they may apply the new qualifying disbursement rules and compliantly make grants. And really, in that guidance, there's a reference to accountability tools, which CRA recommends that a charity use to help just understand how it meets its accountability requirements. So some of these tools include things like a due diligence review of the grantee, a description of the grant activity, and monitoring and reporting, for instance. So while Canadian charities can currently make grants to non-qualified donees, it's recommended that they do so with prudence and expert advice, particularly now as CRA's guidance on the topic is still in draft. And it's expected to be finalized in late summer or early fall at the earliest. And so it's important to kind of look at things from a risk-based perspective and with proper advice. For those of our listeners who are from nonprofits without charitable status, while the own activities and qualifying disbursement rules don't apply to you, it's still important that any of your resources be used exclusively for your nonprofit purposes and not for some other purpose, including revenue generation. And there's a whole analysis we can go into, but perhaps for another session in another call.
Thanks, Pam. Kelli, did you want to share some thoughts from the US perspective?
Yeah, my thoughts are pretty similar to what Tony and Pam have said. From the US perspective, the options that we usually see are grant making, whether that's being inbound or outbound, as well as direct activities that a nonprofit might engage in a foreign country. On the grant making side, there are a number of requirements that, similar to the rules that Pam discussed. Generally, you're seeing a lot of it in the 501c3 world. And there's some pretty distinct differences if you're a private foundation that's engaging in cross-border grant making versus a public charity that's engaging in cross-border grant making. Private foundations are subject to some really pretty onerous administrative rules regarding oversight of their cross-border grants. Those are, we generally refer to as expenditure responsibility, is what we see most of our U.S. foundations making cross-border grants engaging in. And that requires a fair amount of due diligence on the front end, a written agreement with the donee organization, as well as a ongoing reporting from the donee organization to ensure the grant funds are being used in compliance with U.S. tax rules, as well as the donor's charitable mission. Equivalency determination, just to touch on that quickly, is if you don't engage in expenditure responsibility, equivalency determination is another alternative to ensure compliance with the U.S. tax rules. And that's just essentially engaging in a determination that the donee organization is equivalent to a U.S. 501c3 organization. And that's generally done by outside counsel that would engage in that determination. And it can be pretty onerous because you're working through all of the rules. And then the final one, just to touch on briefly for private foundations, is just advance approval. If you're going to be making certain types of grants to individuals, and honestly, whether they're in the US or outside the US, you have to get advanced approval for your grant making activities from the IRS. And so that can be an additional step that can be surprising to nonprofits. And then just from a public charity perspective, we'll often advise people apply at least some level of the private foundation rules as a best practice, even if you aren't required to do so. A level of due diligence, a level of reporting from the recipient donee organization, but do it in accordance with like what makes sense for that type of grant, like the size of the grant, what the grant's going to be or is expected to be used for. But again, it's not required, but it is best practice to engage in that sort of oversight.
Great. Thanks, Kelli. That's really helpful. So Christie, what are the key corporate law requirements that charities and nonprofits should consider when they're exploring establishment in a host country?
Sure. It's important to recognize, in addition to what Kelli described, which is more relating to grant-specific activity, that your physical activity and the activity that you're conducting within the US is largely driven from a corporate law perspective by where that activity is happening. And so that can be fairly daunting to think about when you're entering the US, given the fact that the two first things that come up is, first, many states require you to be qualified to do business, and that varies by the state as to what type of activity constitutes business in that state or whether there's an exemption. The second part is that fundraising and soliciting of funds, meaning where an event is happening or where someone is cutting their check or receiving a request to give money, is largely driven by the state where that request is met. So from a fundraising and a solicitation requirement, if you're picturing a decision tree, if you're engaging in that activity, it usually requires some additional separate analysis. Sometimes, not always, you have to be qualified to do business to even solicit. That's an exception. But ordinarily, there's some ability to just look at what your activity is and see if you need to be registered in the state. There's a number of exemptions and there's a number of toolkits that are out there to help. So the good news is this is an area where if you're engaged in new activity and you're doing something here, there are a number of resources out there, and we cite to some later in our slides that'll be available to you. But just so you're aware, there are 41 states plus the District of Columbia that do require some level of registration when you're soliciting contributions. And in addition to the fundraising part, if you're going to have employees, physical stuff, applying for grants, some other nexus to the US, that oftentimes there are states that will require that. So this is a good situation in which I know one of the themes we talk about, if you're doing something new or you're entering into a new jurisdiction, it's really good before you do that to sort of consult one of these resources and compliance tools that are out there and see if you're doing something that might be covered there. Pam, I know you're going to expand on some other points. Why don't you go ahead, and if there's anything else, I'm happy to add after.
Sure. Yeah. So on purpose alignment, I think it's really important to point that out. It could seem obvious, but looking at your purposes for which you've actually been incorporated and ensuring that any movement of funds, activities, information, or people, it's all with a view to furthering those purposes as a first priority. Sometimes it's, again, obvious, but it's important to point out that there is a need to review incorporating legislation for your organization, and if there's any requirements that you need to comply with, if you're contemplating these kinds of cross-border actions. And then looking at, of course, your governing documents of the home country's entity. So your bylaws, your articles, your policies, and any special resolutions. These will all say something about how resources may be used by the corporation. So it's also critical to point out that when you're looking at looking at host countries and evaluating which host countries you might be exploring as options to establish operations or programs in, working with local council to set out those options is critical, because they're the ones with the expertise and they will be able to provide the array of options that might be available to your home country entity. And then two more points just around the board's role. So any cross-border actions, particularly those that involve establishing new entities in foreign jurisdictions, we really need to look at the board's authority and ensuring that any resolutions that might need to be passed and considered by the board in doing those actions, that those steps are taken and that they're documented in minutes and resolutions accordingly. And that there's also an understanding of the corporate readiness for even delegating authority to management of the new entity or the branch, because that governance chain and the accountability chain does need to kind of come full circle.
Thanks, Pam. Christie. Kelli, what tax requirements should be considered when exploring establishment in a host country? And then Pam, from the Canadian side, if you can speak to that as well.
Yeah, from an entity entering the US, I think the main thing to think about from a tax perspective is just to know that our tax exemption requirements are not uniform. They vary from the federal level to the state level and even at the local level, down to the cities. And then you also have variances from state to state, and those can vary pretty significantly. For example, some states you have to separately apply to be tax exempt from income taxes. Other states, if you're exempt at the federal level from income taxes, you aren't going to be subject. You don't have a separate application at the state level. So there's a really wide variances, and you're dealing with 50 states that have 50 different views of things. And then you also have to take into account that you have different taxes. The tax exemption that you get at the federal level is for income taxes, but we have a lot of different taxes that charities might be subject to, and those will range from sales taxes to property taxes, to employment taxes and other potential taxes, but those are the primary ones that we see charities subject to in the US. The other thing to think about, and I alluded to it when I talked about employment taxes, is if you have employees that are in the US or traveling to provide services in the US, you may be triggering employment taxes at not only the state level, but also the federal level. And that triggers reporting requirements, withholding requirements, and the like. And again, it varies from state to state and from federal to state as to what those requirements might look like and whether there's a particular hurdle or threshold that the employee would have to exceed from a time perspective or money perspective before they're subject to a particular state or the federal level taxes. And then the other thing, just one quick thing to think about, which isn't like specifically taxes, but it is tax exemption related, is just what I previously talked about, are the oversight requirements, just the general 501c3 or 501c requirements that nonprofits are subject to in the US from a tax perspective.
Yeah, and
over to you.
Thanks, Kelli. And to, I won't add and just say agreed in terms of the different tax requirements in Canada around thinking about employment tax related issues. If you're dealing in the nonprofit space, for instance, and we're not dealing with charities, sales tax considerations, and all of the things that were already mentioned with respect to the own activities and qualifying disbursements requirements. And establishing tax compliant relationships between home and host country entities. So for instance, the need to avoid, intercompany transfers or shared services without proper documentation, or just monies being and funds being transferred again without proper documentation. So we need to make sure that all of those things are covered, and that again, the appropriate tax compliant relationships are arranged. And then looking specifically at local council and working with local council to ensure that host country entity requirements will also be adhered to. So if there's payroll tax or value added sales tax, and maybe there's withholdings taxes that need to be applied or considered, that all of those are also considered with respect to the local requirements. If there's an entity that's being established in that local host country as well, working with local council to ensure that that entity will have tax exempt status, so any income that it receives will again not be taxed. And then I'll just mention the concept of tax treaties. And so here, for instance, we have clients with 501c3 status in the US that might be seeking to expand their donor base to Canadians. So it's important to think about what tax treaties might apply. For instance, under certain provisions of the Canada-US tax treaty, it permits gifts by a resident of Canada to US tax exempt entities that would be eligible to be registered as charities in Canada. that those funds be treated as gifts to a registered charity. So it's important to keep all of those pieces in mind as we're thinking through the tax considerations for cross-border actions.
Good, thanks, Pam. So we're going to go into our final main topic here, broader compliance requirements, and going to ask the speakers to kind of be a little bit zippy on this so we stay within the time requirements. So Christie, if you can start us off and talk about some of the regulatory compliance requirements that apply to charities and not-for-profits.
Sure. Up until now, we've largely focused more on the nonprofit specific assets, but I wanted just to acknowledge a few things here. First, in the US, each Attorney General's office tends to have oversight over nonprofits. So to Pam's point earlier, sometimes it's making sure donor intent is honored, but it's also sometimes if you're transferring a significant part of your assets, and it could be real estate or an intangible like intellectual property, there can be oversight. So just to be aware that that's an area that nonprofits should be aware that there is this state oversight over charitable assets in the jurisdiction. We've talked about fundraising. Some of the other things that come up are people moving. So immigration status, oftentimes there'll be questions with respect to when or how employees may need visas or changes in status with respect to anything that they're doing as they move in connection with the nonprofit's activities. And transferring of data is a big one. So data privacy and considering of when data is either transferred across borders or shared with another organization. And this is particularly relevant and important anytime healthcare related information or personally identifiable information. So those are the types of things that we're just issue spotting here beyond the scope of our particular practices, but the types of things if we're outside GC that we're often flagging, saying that you need someone else to take a look at this with you. In the interest of time, I'll hand it over to Pamela.
Yeah, and agreed. Those are some of the key issues for Canadian charities as well. And I'll just add to that. Indeed, we have our own provincial fundraising legislation in certain provinces in Canada. There's also the need to ensure a proactive privacy and data security program. And particularly for organizations that have a child or youth focus, safeguarding programs are also important to think through and to have in place. And then there's also sector-specific regulation to think through. So if you're from the health sector, there's specific privacy laws that apply. If you are a child welfare organization, also certain special legislation and regulation that applies, and so on and so forth. So there's a host of other legal and regulatory compliance considerations, and we haven't even touched on applicable international laws and regulations and best practices, for instance, but there's a lot to be considered here.
Great. So Pam, continuing on a bit, so did you want to talk about the regulatory environment?
Yeah, so and it's always evolving in the charitable sector and the nonprofit sector. As we know, there were recent changes even in Ontario with a new corporate act coming in force. And so a lot of organizations that are charities and or just nonprofits in Ontario are working hard at transitioning to a new act. So I think here, a best practice to stay on top of all of these changes is to ensure there's a continuous improvement and learning feedback cycle, just as a principle for keeping up with the changes. There should be an annual cadence of review for policies, procedures, and protocols if you don't already have an annual review cycle. And of course, functional ownership. At the end of the day, compliance is, yes, everybody's accountability across an organization, with the board being the most accountable. But functional ownership is helpful to actually get the work done and making sure that there's organizational compliance.
Yep. Kelli, anything to add to Pam's comments?
I think I just quickly add that, just talking with your advisors about what your business plans are going to be is that's going to help issue spot and identify, what things have changed that may now apply to your organization.
Okay. So also, are there resources, Kelli, that are available in the US for entities, charities looking for some compliance support?
Absolutely. There's a whole host of what you're looking for. I find the IRS website to be really helpful because it doesn't just talk about, tax issues. It talks about what the IRS views to be good corporate governance, identify some of the issues that they think are sort of the hot button issues. Things you can look for on the IRS website are just subscribing. They have an exempt organizations update that comes out maybe every week, maybe a little less than that. That's really good. Kind of identifies things they're thinking about, things that have changed. Other things, just review the Form 990 every year. It identifies what they're changing on the 990, and that gives you insight into what they think are hot button issues. And then there's a whole host of other things. You can look on the Attorney General website and a number of other areas or websites that are on here that'll have a bunch of resources and just try to have guidance for charities and other nonprofits operating in the US.
Great. Thanks, Kelli. So Tony, on the Canadian side, can you give us an indication of resources that are available?
For sure, all kinds of great tools out there. Excuse me, to explain these complex rules that I've been talking about. CRA has all of their guidance on the website, so you can look them all up, read them, print them, and share with your folks. To complement the guidance, the website also has a bunch of videos and graphic educational tools that you can download and use for your training processes. The CRA also provides information sessions on all kinds of topics so that you can actually register to attend. In addition, you can subscribe to their mailing list. That'll keep you up to date on all the changes that are going on, whether it be small legislative changes, procedural changes, or whatnot. So you can have them emailed right to your email box. At the same time, you can apply to or subscribe to their RSS feed. That will have all the news releases, so you know if there's any major announcements from the ministers or government in general. But the easiest thing is you can call the CRA Charities Directorate directly. They have a 1-800 number. I'm actually going to post it on the chat because CRA has a number of 1-800 numbers, and a lot of folks call just the general one that leads them down the tax inquiry path, but sometimes that gets lost. So I'll post that right now, and everybody will be able to get to the actual website. And then the other thing you can do is go through your CRA portal. There's the My Account and the My Business account. And there you can submit documents, you can ask questions, and you'll get documentation that way. So lots of great resources available to everybody.
Great, thank you. Okay, so we've gotten to the end of the main program, so we have a little bit of time for questions. I see something here. There's a question about immigration requirements. When staff from one country may be visiting the other, what concerns might be there be to consider? So I think, well, Christie, you were talking a little bit about that. Not sure who wants to grab that question.
I just acknowledge that that's a good time to reach out with ahead of someone traveling with some details surrounding what they're traveling for, the length of time and otherwise, and certainly to be proactive about knowing when someone can travel and if that's a regular thing that comes up, have some general rules in which you know how to operate. And if it's a one-off thing that comes up, that's definitely a good reason to reach out.
Great. And so Pam or Tony, on the Canadian side, anything to be concerned about related to immigration and movement of people?
Yeah, certainly all of the things we've already discussed around direction control and the own activities test, as well as qualifying disbursements. We have to have an understanding of how people are moving and what's the actual relationship that the charity or nonprofit has with the host country. And then getting some clarity as to what the plan of action is really with respect to the particular individual that's going over for a certain period of time, you might be able to go on a visitor's visa for shorter periods. But if there's actual business being conducted, then there does need to be a proper consultation to understand what the immigration requirements might be, both from your home country perspective and the host country.
Great, thanks, Pam. So, good. So we've got a couple minutes left. So let's go around the hoop here and a quick takeaway from each of our speakers. We'll do Christie, Kelli, Tony, and then Pam.
Wonderful. Thank you. I would just reiterate, keeping your advisors engaged on what your plans are is a really great way for us to issue spot ahead of time. So even if it's a check-in or otherwise, don't be afraid to have your accountants, your insurance brokers, and your lawyers speak if they need to. Sometimes they really can anticipate and work well and efficiently to address issues and direct you on the right path.
Kelli?
Yeah, my takeaway would just be that nonprofits are all unique. The nonprofit across the street is going to be different than your nonprofit, even if you're doing similar activities. So just understand that and understand that you can't rely solely on what they're doing from a compliance perspective in determining what your compliance obligations are. So you just need to do your own investigation.
Great, thanks, Kelli. Tony?
I'll go back to, again, encouraging folks to call the CRA. The Charities Director is there for waiting for your call. Don't be afraid to ask general questions, anything about, going forward on a new project. They're there and they're certainly going to help you out.
Great.
And then I'll just end us off with back full circle on compliance excellence. And really, compliance excellence should be the standard for charities and nonprofits, especially those that are expanding programs and operations and might already be engaging in cross-border activities. It doesn't have to be complicated or costly. We got to make sure we keep it simple and principles-based.
Okay, we have one little question here. Maybe we can sneak it in under the wire. Pam, for an Ontario-based registered charity, what provinces do we need to be registered, and assuming we plan to raise funds in all provinces?
Great question. So in the provinces for provincial legislation on fundraising, we need to look at Alberta, PEI, Quebec, and Saskatchewan. I will say that there is also guidance from the CRA with respect to fundraising, and even from umbrella organizations like Imagine Canada on standards for fundraising. So even if you're not going to be needing to register in those particular other jurisdictions, fundraising requirements are things that need to be considered across the board, not just in one or two or three or four particular jurisdictions in Canada.
Okay, great. Thanks, Pam. And that brings us to the end of the program for today. So thanks to all the speakers, really appreciate their insights and input. And thanks to everyone who attended today. And a reminder, the recording will be circulated to all attendees in the coming days. And if you have any questions or like to have further discussions about the content covered, you know who the speakers are, so you can reach out directly and hopefully they can provide some further guidance. So great. Thanks so much to everyone and have a great rest of the day.